We're adding to the conversation Darryl Stallworth. He's a criminal defense attorney with over 30 years of experience in the courtroom. Thank you for being here. And the way the system works is, as a defense lawyer, you have an ethical duty to provide your client the most vigorous defense you possibly can. True?
Absolutely. 90 years ago, the California Supreme Court was reviewing a sexual assault case, and they pointed out that this particular charge flips the presumption of innocent to presumptions of guilty because of the difficult layers that are involved. They talked about how the burden shifts from the prosecutor's burden of proving a case beyond a reasonable doubt to a defense attorney having to show that the client's innocent. So I am understanding that and appreciating that over the 30 years. I've seen those challenges, and I know that I have to provide a professional, strong challenge to every accusation.
You owe it to your client to do it, and it's unethical if you fail to do so. It's estimated that between 2 and 8% of allegations are false. And when those allegations are false, the consequences can be devastating for the person. But tells us that 92 to 98% of the allegations turn out to be true if we believe those statistics. Has the system gone too far?
The system requires that those things and those accusations be challenged because the mere statement by someone is never going to be enough by itself to carry a case. And if you don't have a witness, if you don't have circumstantial corroborating evidence, you have to challenge the credibility of that witness. And that requires the level of challenge, questioning the history, the mental state, the timeline, all those things that come into play. These are things that have to be vetted. And I, as a professional, I have to be surgical with it. I have to do those things to make sure that my client is properly represented.
If it's a he said, she said.
Challenging the accusation is different than challenging the victim.
Mm-hmm. I understand that, and I can appreciate that from your perspective, but when a jury has to make a decision on whether or not the accusations are credible and trustworthy, then you have to challenge that person. You have to put into perspective that if someone's making a statement that they saw a green truck down the street, then you've got to ask them, where were you standing? How do you know it was green? What was your mental state like? Do you have a history of not being truthful? These things are things that have to be asked. And I know they're uncomfortable, and I know they're difficult, and I know it's traumatic, but they have to be asked. I've had a number of cases over the years where people have made these accusations, and it turns out that they've talked about things that are impossible. They talked about things that are inconsistent with what they said before. They've said things based on bias or motive that comes back, and we find out that they're not being honest or truthful. So as difficult and as painful as it is, it has to be vetted.
I take issue with what you said. You're quoting a statement from the Supreme Court for 80 years ago. You are aware that until 1992, it was legal to rape your wife in this state, right? So when you say that it's guilty until proven innocent, I find that completely the opposite. She's lying until we can prove that she's not.
But when someone's accused of sexual assault, the social media and the public image that presents itself creates this sense of this person being guilty. If you take for 1 second just the idea of what it would be like if you have a son or a nephew, and that person's accused of sexual assault, that person becomes canceled. That person becomes defamed. That person becomes a lot of trauma.
You are conflating what we do in the public eye with what is legally done. There's a very big difference. Okay, there is no legal consequence, but there can be accountability through societal norms. Let's talk about the law, though. What are we doing to actually investigate and prosecute rapists? I consider myself an advocate for in the criminal justice system above all else. Everyone deserves a defense, first of all. But do you really need to bring up everything a person has ever done in their entire life, whether they've ever had, have you ever been to therapy? Oh, then obviously you're unstable.
There's no other crime where your sexual history is put on display as when this is brought out into the open.
Your history of being credible, your history of being truthful is relevant when you're making a sexual assault claim. It doesn't have to be a past sexual relationship. I want to know whether or not you've ever lied about something before. I want to know whether or not you ever made an accusation that's been false. There are false accusations that are being made where people are eventually exonerated. But once that bell is rung, you can't unring it. And what I'm saying from the defense point of view is that it has to be vetted. It cannot just be assumed because the statement is said. Because when you say the word sexual assault and rape, it automatically has a reflection that someone's guilty. It's unlike murder, it's unlike robbery. It requires extra challenges because it creates such a presumption of guilty right from the start.
But
If
how-
I take your watch off your hand and I say, you gave it to me, are we going to go to court and they're going to say, have you ever given anyone anything? Have you ever given a piece of jewelry to someone? Have you ever lied about anything? Because how do we know that you're not lying about this now? Because you've lied at some point in your life. Because that watch, it's not going to hurt you if I take it off of you. But if you take something off of my body, it does. It hurts me for the rest of my life.
It's exactly what's supposed to happen. Everything that comes through the court, every accusation that's made, every statement that's made has to be challenged. Sexual assault and intimacy is one of the taboos of the society. Nobody wants to talk about it. Nobody wants to talk about the parameters. Nobody wants to talk about communication. We've got high school kids having sex for the first time. They don't know what they're doing. We've got kids in college thinking that they're being aggressive, but they're being assaulted. This conversation that we're having has to be a conversation that takes place early in everybody's lives. Parents have to talk to their kids. Students have to talk to each other. We have to develop more information so that these tragedies do not exist.
No, I agree with you completely there. And I worked with a lot of young people, and the biggest issue we have is that they don't know consent. And if you're in a state, which I'd like to also mention, that says sex is bad, don't do it, it's evil, I also want to mention that children that have been sexually assaulted as children, they're hearing that sex education. That's not good for them either. We need to teach respect. We need to teach continuous consent. We need to teach enthusiastic consent. I agree with you there.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.